at Boston, within and for the Commonwealth, draw near, give me attendance, and you shall be heard. God save the Commonwealth of Massachusetts. Court is open. Please be seated.
Good morning. Welcome to the January 8th, 2025 sitting of the Massachusetts Appeals Court. Let me introduce our panel for today. Sitting to my right is Justice Joseph Ditkoff. To my left, Justice Chauncey Wood, and I'm Justice Eric Neyman. We have 6 cases on for today. Normal appeals court rules are in effect. Each side has 15 minutes to present argument. There is no rebuttal. I can assure you that we have read the briefs, we are familiar with the record, so I would urge you to cut to the heart of your argument. However, your 15 minutes is yours to use as you see fit. One final note, on occasion you will see the justices looking down at their iPads. I want to assure you we are not reading the Globe, Herald, CNN, the funny pages, any of that. We are merely checking the record in real time. We have before us your briefs, the cases, and the record. So with that in mind, let me call the first case. Docket 24P332, Commonwealth v. Morales. We'll hear first from counsel for the appellant. Good morning.
Good morning, Your Honors. John Raymer for Juan Luis Morales. Your Honor, please. Reasonable provocation has 2 requirements: an objectively adequate event for provocation and a subjectively intense emotional reaction. The charge in this fails on both requirements. The first requirement, in this case, that was Lee Daniels advancing on the pavement, telling Mr. Morales that he would kill Mr. Morales in the light most favorable to the testimony given. Your Honors have probably seen the video. There is a total of 16 seconds between the time Daniels leaves the car and the 2 men are engaged in a struggle. So that's how much time, that's how immediate, and that's how serious the event was. The jury instructions gave a reasonable juror no legal means to interpret the significance of that. All they were told is that ordinarily mere words don't amount to anything. And a reasonable juror could decide that that meant, well, this death threat, I should just ignore it because it was mere words. And that is, of course, not the law. You look at the case of Commonwealth versus Little, a 2000 case. There you have 2 men who meet on the street in Jamaica Plain, and one of them says, then I'm going to kill you, but in the vernacular, I'm going to fuck you up. And the defendant in that case is alarmed, thinks that maybe his opponent may have a gun. He didn't, but he thinks that, and shoots him. And that was reasonable provocation. Whether a death threat is a serious provocation or not depends not so much on the words, but the context in which they're set. My brother cites a case of Commonwealth versus Estramira, and that was a police officer who shot a man who had been searched and was in custody in the back of a cruiser where he could not carry out the threat at all. This case is different. The threat was very capable of being carried out. And a threat to kill, when it's capable of being carried out, is the crime of threatening to commit a crime.
Remind me, did the decedent have a weapon on him?
No, he did not.
All right.
So with no way to process the significance of the threat to kill in circumstances where it could be carried out. The jury was left hanging, and with the the unhelpful words that
What do you think the instruction should have been?
that the jury, that while mere words are generally not sufficient, you may take into account whether these words put the defendant in immediate fear of serious bodily harm and with the apparent ability to carry them out. Basically, a patch on threat to commit a crime.
What's your best authority for that proposition?
I thought of it. I know I don't know what the law is in other jurisdictions. I can only say that in this case, it's time to go back to the book.
What about where the judge said, and this is at volume 6, page 82, in sudden combat, physical contact, even a single blow, may amount to reasonable provocation. Whether the contact is sufficient will depend on whether a reasonable person under similar circumstances would have been provoked to act out of emotion rather than reasoned reflection.
Well, that's because reasonable provocation and sudden combat are two different things. Sudden combat is a smaller example of what reasonable provocation can be. You know, in a Venn diagram, that would be inside, but it didn't encompass all of reasonable provocation. And as in the Little case, there was no combat. The fear of deadly combat is exactly what the reasonable provocation consisted of. So one is no substitute for the other.
Don't you think the Little jury was told the mere words instruction when they convicted the defendant of manslaughter on remand?
I don't know the history of the case on remand, or whether it was, in fact, retried.
Doesn't the word ordinarily do most of the work for your argument?
Well, that's a lot of work to pile upon the one word ordinarily. What's a juror going to make of ordinarily?
Can you tell me one more time your answer to Justice Ditkoff's question, what the instruction should, the patch, what the small patch should be? I didn't quite catch it.
Although standing here on my feet, I can't give you the instruction in full, but the instruction could be something like whether the words put the defendant in fear of immediate danger, serious bodily harm in conditions where it might be carried out or could well be carried out. And that would get rid of, teasing and insults, but it would give leave to people who are seriously and reasonably in harm. I mean, a person who is not put in harm, in fear or nervous excitation by that is not reasonable. He's just dead, emotionally. I would also mention that, I'd also mention that the proviso, well, except for giving information, well, that's from the sudden disclosure of adultery cases. That's Commonwealth versus Schnapps. And if you look at the jury instructions, the model jury instructions, they cite to Schnapps in a footnote to that instruction. As the Commonwealth mentions at page 17, this is not a case where someone was disclosing information. And no juror would think that I'm going to kill you is disclosing information. That's a state of intention, which is different. The subjective part of the instruction was deficient. The provocation has to incite a level of anger, fright, or nervous excitement. Well, just how much of these qualities does it have to incite? And the instruction gives us the answer to that. So severe as to make an ordinary person, quote, incapable of reflection or restraint. Now, in plain English, incapable means having no power, having no ability, having no capacity. It is equivalent to saying no choice. And how can you say that someone has no capacity? How can the defendant ever prove, well, I had no capacity, rather than this really unnerved me? But it's a standard impossible of proof. And a jury could well say, well, this gentleman may have been very, very shaken up, but to the point where he had no choice, to the point that his ability to refrain was just incapacitated, that's going too far. And this is an anomaly. We don't even do this in duress. We don't even do this in insanity. Substantial impairment is the level, not complete loss of ability, not irresistible act, substantial impairment. So the instruction was defective in that case. It just set the bar too high.
Could I move you to your last issue? I'm particularly interested in your last issue, whether the judge abused her discretion in declining to reduce the verdict to manslaughter. And in particular, I'm interested in the aid in sentencing letter that Attorney Weinstein got from the clinical psychologist. And in particular, I think it's interesting that it reveals parallels with the defendant in Pagan, where a first-degree murder was reduced to second-degree murder, and the defendant suffered from a lot of the same issues. Could you speak to that issue?
Yes, Your Honor. I realize that abuse of discretion is a very high hurdle. All I could just say is that in view of the cases where it has been done, and in view of the modern trend with Ditkoff and Mattis of saying that as a class, emerging adults are less in control than they would be as adults, that would be a just verdict. It would be just to reduce the sentence to manslaughter.
Right, but we hear that, I take your point that Mattis changed the world in a lot of ways, and we're now recognized more sensitive to emerging adults. But here you have much more than that, don't you? You also, thanks to the aid and sentencing letter, you have information that Mr. Morales had a long history of anger control issues. You have the history, the fact that he had very low intelligence. He might have been intellectually disabled, measured in the 13th percent. You also have ADHD and depression. In other words, you have a lot more than just that issue. And so I'm wondering if you think that was sufficient, and if so, why? To warrant a finding that this was an abuse of discretion, to deny the 25B2 motion.
Your Honor, that is, I acknowledge, the weakest of the arguments I presented. How much to give this man a second chance rather than a life sentence certainly is a question that's disturbing and very hard to answer. So I'm not going to stand here and blow smoke at you and say it's not.
Thank you.
The other arguments are whether the gentleman should be, the standard should be a reasonable adolescent, since he is a reasonable, or he is an adolescent, and they have the class characteristics mentioned in Mattis. You don't have to go and re-examine every defendant. As a class, they are susceptible to the defects noted in Mattis. The other argument was that mentioned in HOELAND, that although use of a dangerous weapon permits an inference of intent to kill, that should not be highlighted by a judge because it helps the Commonwealth with its burden of proof. That's a job for the prosecutor. It's not the job of the judge. I realize I have 35 seconds, and I would like to finish under budget and under time.
Seeing no further questions, thank you very much, Attorney Reamer.
Thank you.
We'll now hear from the Commonwealth.
Good morning, and may it please the court. Jesse Crane for the Commonwealth. I just want to first start by acknowledging the presence of the victim's family today in the courtroom. I'll start first with the jury instructions, and I'll just note that the mere words instruction that the defendant has pointed to did not create a substantial risk of a miscarriage of justice. The trial judge read nearly verbatim from the model jury instructions, and the SJC has repeatedly admonished trial judges not to vary from the model jury instruction on homicide. That's discussed a little bit in Howard in a similar context here. And I would also say that in context that this section of the jury instructions did allow the jury to consider threats. The full text was that mere words, no matter how insulting or abusive, do not ordinarily by themselves constitute reasonable provocation, but there may be a reasonable provocation where the person killed discloses information that would cause a reasonable person to lose his self-control, and so learning the person did. I think from that context, the jury certainly had the option to consider the threat in terms of reasonable provocation just from that section. And moving to the prejudice prong of the substantial risk of a miscarriage of justice standard of review, the jury also could consider the threat in 3 other theories that they were instructed on: sudden combat, excessive use of force in self-defense, and excessive use of force in defense of another.
Well, I agree with that, but in your brief, you stated page 17 that there was no evidence that the decedent, quote, conveyed inflammatory information to the defendant. Wasn't there evidence here from the defendant himself that the decedent, upon approaching him, or at least at some point after he drove by, said, "I'm going to kill you"?
Yes, in the light most favorable to the defendant, that is correct.
Wouldn't that constitute inflammatory information?
I think it potentially could, but I look at the Benjamin cases.
In the light most favorable to the defense, doesn't it convey inflammatory information?
I think when you have words mixed with gestures, and I'm looking at the Howard case when I say this, that could convey inflammatory information. But in this case, unlike in Little, the victim had his hands raised to the air. He was clearly unarmed. I think when you contrast that with the Little case where the victim was reaching for a weapon, the defendant knew the victim was armed. In that case, the threat plus the gesture was an inflammatory information. I think because there are some key facts lacking here, I don't think that the threat here rose to the level of conveying inflammatory information.
Sorry, I watched the video. So first of all, you don't need the video, but the guy, the decedent pulls his car over, gets out of his car, and starts walking towards the defendant. I think everybody understands that that moment we have an unusual situation. Doesn't that, plus the verbal threat, constitute inflammatory information in the light most favorable to the defense?
It certainly may not have been a it was not a friendly gesture. I recognize that it was perceived as aggressive, and that may be objectively so. The question is whether it rises to being objectively reasonable for the defendant to be so provoked. And I guess I just would back up here and note that the defendant did receive this instruction. So whether or not he was entitled to it, he received the benefit of it, which again just goes back to the question of was there any prejudice from this, even if the instruction was an error?
By this instruction, you mean the adequate provocation instruction?
Yes, that correct.
Was there any objection at trial? I believe the answer is no, but was there any objection to the self-defense instructions?
I don't believe so. I don't believe either party objected to the self-defense instruction. If I remember the jury charge conference correctly, the only objection was to the inference of malice from the use of a deadly weapon. I'll just move on to the closing argument. I'll note that the prosecutor did not misstate the evidence here. The defendant's testimony was vague. The prosecutor had attempted to discern when the threat was made. The defendant gave a vague answer of just after the white car had pulled up into the street. The entire altercation happened after that point, and the fact that the defendant didn't pinpoint whether the victim was in his car on the side of the street or near him on the sidewalk, I think leads to the permissible inference that the defendant was vague and couldn't identify when exactly the threat was made during the very brief altercation. If there are any questions on issues 3 and 4, I would be happy to take them.
Counselor,
Sorry, go ahead.
Oh, no, go ahead. Please go.
I'll ask essentially the same question I asked Attorney Romer. I don't know if you had nobody cited Pagan, but I think that Pagan is factually very similar. I recognize that it is a first-degree murder reduced to second-degree murder under 33E. I also recognize that the jury was given the testimony of the expert in that case, and here the letter, the aid sentencing letter, was not given to the jury, so the jury didn't have a chance to consider it. But given all of that, is there any, why should we not be troubled by this array of factors in considering whether this should have been reduced to manslaughter?
I guess I'll just start by noting my brother didn't raise this in his brief, so I would argue the argument is waived. But going to the substance of the question, I think this was an aid in sentencing report. It wasn't given, the defense didn't introduce this as expert testimony at trial, so the fact finder didn't have the benefit of it. The expert wasn't subject to cross-examination, so we have essentially a hearsay report detailing some factors about the defendant, but not really in a way that helps the fact finder. And the trial judge, I don't think in those circumstances abused her discretion by not factoring in the aid in sentencing report where it wasn't part of the evidence.
If I could, I appreciate all of that, and that strikes me as very reasonable, that response. But just stepping back and drilling down for a second, you said the defense didn't raise this point. I take you to be saying the defense didn't raise that aid in sentencing letter should have been considered in the 25B2, but the defense did raise the question whether the judge abused her discretion in denying a 25B2 motion. And she could consider the aid sentencing letter in that ruling, couldn't she?
I think she was limited to the evidence that was actually admitted at trial rather than just the sentencing hearing. I mean, again, because this was a hearsay report, created by someone who was never qualified as an expert, I think it was helpful for sentencing. And obviously, we have many cases that have addressed emerging adulthood and the science of the brain of emerging adults in the sentencing context. But I don't think even this report went to the issue of reasonable provocation beyond, some fairly standard language about, emerging adults being emotionally reactive.
I appreciate that. Do you have a case that supports your position that on a 25B2, the judge is limited to the trial record, heard by the jury?
I candidly, I do not have one off the top of my head. I believe in my brief I cite to Lyons, which does address a situation where a trial judge had reduced a verdict and the SJC found that she had considered extraneous factors in reducing that verdict. Although I don't want to overstate what that case says because I'm not positive on the details.
Thank you very much.
Of course.
When did the judge rule on the motion to reduce? Was it before or after sentencing? I can look it up. I thought you might know.
Yeah, I apologize.
I can look it up. I thought you might just know.
Yeah.
This thing in the appendix that says sentencing, like near the end of the appendix, sentencing Jose Morales. Do you know what this is?
Are you referring to
not the aid in sentencing? Right after the aid in sentencing in the appendix, there's this thing called sentencing Jose Morales, and looks like the judge's voice.
I'm not. Was this in the appendix I submitted?
No, the defendant's appendix. I forgot to ask your brother.
I apologize. I'm not sure. I remember the aid in sentencing report. That was the bulk of my brother's appendix. I'm not sure if there was a written decision on the docket.
All right. Last thing I just want to say is that when I read the opening, I had the same impression that the judge did. So you may want to convey to your predecessor that wasn't an idiosyncratic reaction by the judge, that it strikes other people that way as well.
Of course.
Final question from me. Have we ever held that discretion within the context of a 25B2 motion is LLV Commonwealth discretion? That is, we look to see whether it's outside the range of reasonable alternatives. Has it ever been defined that way, to your knowledge?
Not to my knowledge, no. Although I would suggest that it is the same abuse of discretion standard as any analysis of what a trial judge does under that standard.
Okay. Anything further? Anything further? Okay. Seeing no further questions, the case is submitted. I want to thank counsel for both parties. Well presented, and we'll move on to the next case. Thank you. And our next matter is docket 24P81, Commonwealth v. Trapania.
Good morning, Your Honors. I'm Jim Peterson, and I represent the Commonwealth in this case.
Good morning.
Your Honor, the heart of this matter is twofold. That the judge abused her discretion by rewriting Rule 36, and she did that as a sanction that, while she said it was remedial, was a punitive sanction. And punitive sanctions under Rule 14C are impermissible. The first aspect of this, Your Honor, is the Rule 36, which is the subject of this sanction that the judge gave. Rule 36, it's promulgated under, of course, Chapter 218, Section 43, where the chief of the trial court promulgates rules after the Supreme Judicial Court approves them. This judge just rewrote Rule 36 without any authorization, and there is no case that we can find that authorizes a judge to do this. She has taken, in fact, the Rule 36 cases are pretty clear on a lot of other things, such as the excluded time, for example. If it's excluded, it is excluded time if it fits a category. There's a great deal of case law on this and how we do it, and Rule 36 protects a defendant's right to a speedy trial, which is the justification the judge gave for doing this, that I'm just protecting the rights to a speedy trial. There is a mechanism, Rule 36 as promulgated.
Counsel, the problem I have is that I really have a hard time understanding what the judge ruled. And that is one way to look at it. But your friend suggests we should look at it as a sanction that the case had to be tried within a year of the sanction date. And why can't we look at the ruling, the order as that?
If we look at the order on that and ignore Rule 36, at that point, it goes to the second argument, which is the second part of this. That is a punitive sanction, not remedial. The purpose of sanctions is remedial. And just as an example, there's the case, off the top of my head, I'm forgetting the name, that's the money case, Frith, that's it, where the judge fines the Commonwealth monetary damages. And the court reverses it because that's not remedial. What you need to do for remedial, it needs to be tailored to cure the prejudice to the defendant resulting from the violations in the first place. The entire point is to prevent irredeemable harm to the defendant that may cause the possibility of no more fair trial. This case, the sanctions, some of these sanctions were perfectly fine. For example, the Commonwealth is going to get the DNA, it's going to do a test, and after that, the defendant has as much time as you need, defendant, to get an expert, take a look at that, analyze it, and then furthermore, it's not clear whether this was the part of the order, but another part of this is that would be remedial and not punitive would be, and I'm not going to allow it until we get to that stage. At that point, we'll have a discussion and perhaps an evidentiary hearing with the defendant's expert, maybe the Commonwealth, to determine whether this late disclosure foreclosed, again, this, what is the irredeemable harm to the defendant that prevents the possibility of a fair trial. The sanctions are intended to preserve a defendant's right to a fair trial. They're not to punish the Commonwealth.
Can I just jump in? If we're looking at this as a Rule 14 sanction,
Yes.
Putting Rule 36 to the side, isn't there case law that says a judge may consider any sanction up to and including dismissal of the charges?
Absolutely.
Okay, so how is that remedial?
Exactly. So the great thing to look at is some of these cases that discuss dismissal. And a good one, for example, is Lam Hu 2, which is in the defendant's brief, actually, at page 13. I think he explains a little more. And that one is, the bare essence of that is that there was a stabbing, police responded, and somebody finds a knife. One of the other officers finds a knife, and there's stains on it. But one of the non-witnesses, somebody says, oh, that's my wife's knife, don't worry about it. The police officer takes the knife, puts it in the car, keeps it, doesn't put it in his report, doesn't do testing, doesn't tell anyone. We get to trial. Defense counsel makes opening statements, has committed in front of a jury to a defense, and finds out on cross-examination there's a knife with stains. Immediately moves for mistrial, dismissal, everything. And the judge does not declare a mistrial, but dismisses it as a violation and a sanction. And what the SJC said in that, I think it was an SJC case, yes, SJC said, is a mistrial is absolutely appropriate in this case. The defendant had committed, but we don't have the facts for a dismissal because the essence of that dismissal, for it to be permissible, is that it is irredeemable harm to a defendant that prevents the possibility of a fair trial. So they sent that back for more findings. Is there any chance to get this tested? Is it too late? Did they lose witnesses? If that's the case, then he may be able to show that he can't get a fair trial. That's when dismissal is appropriate. Here, dismissal didn't come for any purpose about the nature of how this affected the defendant.
Well, the judge made a finding that this was not, that the delay was not prejudicial.
A pardon was not prejudicial?
The judge made a finding here that the delay that will result due to the delayed disclosure will not prejudice the defendant.
Correct.
Here.
Yes, precisely.
So let me move on to a different question. Hypothetically, and this truly is a hypothetical, suppose we agree with you. Suppose we say, geez, the judge really should not have used a sanction that was contrary to Rule 36 or that contravened Rule 36, and we send it back. What tools are left to the judge? What options would the judge have as to an alternative sanction at this time?
Well, first and foremost, I do want to just make one other on this, something that the defendant says as well in his brief, because I think it ties into this. As it stands now, if this case were reinstated, the Commonwealth would suffer no consequences for their unnecessary delay. That's punitive. That the Commonwealth, understandable, that the Commonwealth does not have clean hands here. They were late with discovery. All this is with the fault of the Commonwealth. But so you have this. At this point, you go back. I would argue there isn't anything now because the defendant had a chance and did, apparently, from all these transcripts, get an expert, a DNA expert, looked at it, and clearly there's nothing on the record about his conversations, but he decides to forego that expert and go to trial. So he sets it for trial instead. If he could show that because, again, hypothetical in this case, if he could show that somehow he had an expert who looked at this and who said, you know, I'm looking at the DNA of the defendant, which was ordered, and the sample, and there's something weird in the sample, and I need to test it. And if it turns out because of the delay, this isn't a capital case.
So is your answer to my hypothetical that in your view there is nothing the judge can do if we remand the case in terms of imposing a different sanction? And if that is your answer, I need some authority for your proposition.
Yes, it's not entirely that, but it is the only sanction can come if this is remanded and the judge has a hearing and finds that this delay resulted in irredeemable harm to the defendant that presents
The
possibility.
judge already made a finding of no prejudice.
At that point, I would argue that the remedial nature of the sanction has already been fulfilled. The defendant has gone forward with the remedial side. He had as much time as he needed to do it, completely fair and understandable. And at this point, he has done that and prepared the market for trial. That's the
I'm not sure I agree with your logic. By your logic, if there's a determination of no prejudice, then there's no sanction that can be imposed. I don't think that's the case.
Well, that's the issue here, that these are all designed, all of the sanctions as authorized under 14C are solely remedial. And at this point, if he's received that remedial and isn't prejudiced, any sanction is going to be punishment for what the Commonwealth failed to do, which is to disclose this earlier. And at that point, a judge does not have the authority to make a punitive sanction. If a sanction can come back still as remedial, then absolutely a judge could make a sanction, but I don't see how on this record at this point, when the DNA is done and the defendant has had a chance to review it, had a chance to get an expert, and has decided, clearly from the various transcripts and the motions to extend, has decided not to use an expert, I don't see how he can show that he has been prejudiced by this, which again, the judge made a finding. But at that point, any sanction would be a sanction to punish the Commonwealth, and that's precisely what's prohibited.
I'm having a hard time understanding how we can remand for a trial. Wouldn't the most we could do is send it back for the judge to consider the defendant's constitutional speedy trial claim?
Could do that. We did include this, obviously, because Your Honors could uphold the dismissal if you found that Rule 36 had run already, since this is revolving around Rule 36. And of course, the court has the authority to uphold an order under anything that's on the record. So we did go through it. And absolutely, the defendant in this case did not file, as Justice Wood noted, a Rule 36 motion, filed a Rule 14 motion for the sanction dismiss it, Judge. Absolutely. We could go back, the defendant could file a Rule 36 motion.
I thought the last motion you filed raised the constitutional speedy trial rights, not how the judge ruled on it, but.
In the motion to dismiss.
Yeah.
And absolutely, that could go back and there could be a hearing on that. And it would argue there should have been at that point, rather than simply this, I made an order and said you only have a year, and I'm overriding Rule 36. That's a punitive sanction. And that's the sole issue. Absolutely, the defendant has speedy trial rights. Absolutely, the Rule 36 clock under the rules of Rule 36 are going to be how we analyze that. The judge never touched that. So we don't have an answer to that. So I would certainly agree that if it was remanded for that hearing, but if a judge finds, as we've done in the calculations, I think if we're even close, you see it's certainly well within the speedy trial clock. And at that point, then, yes, it would go to trial or plea or whatever, but it would continue because the speedy rights, the defendant's speedy trial rights would be protected, would have been protected, again, because there is already a way to handle that. You don't need to, the judge doesn't need to do that under Rule 14 as a sanction. That's the entire point of Rule 36, to make sure that the defendant's speedy trial rights are protected with the ultimate punishment to the Commonwealth, which is punitive at that point, but it's statutorily punitive, is it's dismissed with prejudice. So it would be preserved. It should be addressed. I think it's clear that the Commonwealth, we are within the time and it would go forward. But any other sanction, unless it's remedial to address the prejudice, and I just don't understand it, as you said, the judge didn't find it. But again, the judge didn't really go into any great detail in any of this because she found I made an order and you violated it. And that was a choice that on a date that the defendant had picked when the trial attorney was, the Commonwealth's trial attorney wasn't present. The judge noted he actually picked that there were 15 days prior that would have been within the time frame, and he picked the one that landed right the next day on the outside, a Monday right after the date, and then filed a motion for the sanction to dismiss.
One technical question. There's a later criminal case that's traveling with the instant case for a while. Do you know whether that case has the same victim?
I don't, and I did notice that it got dismissed on the day of trial. Oh, I think it was even scheduled for trial.
It got dismissed later, but I just...
And I was curious as well. I did not look it up because I thought it was outside of the record, and I didn't. It does...
All right,
I don't know. I can't answer that. I don't know. It's the short answer. But again, I think under the Rule 14, you can find Lamhue 2, Commonwealth v. Hernandez, Commonwealth, even in that one, in Commonwealth v. Hernandez, which is 421 Mass 272, it's another case where the Commonwealth actually refused to comply with the judge's order, refused to do it, and again, the Massachusetts Supreme Judicial Court found that absent a showing of prejudice to the defendant, you can't dismiss the case. It all revolves around the prejudice. That's the remedial nature, not the sanction. Understand the frustration of the judge at this, but the order, that aspect of the order was a punitive sanction, which is impermissible. And that I will rest on Justice Greenbaum's brief, or I'm sorry, ADA, Special ADA Greenbaum's brief. Thank you.
Thank you, Attorney Peterson. We will now hear from counsel for Mr. Trapania. Attorney Zandrowski, nice to see you.
Nice to see you all. Well, good morning. I'm here for Tyler Trapania. Basically it concerns one issue, and so I'm arguing that the trial court did not abuse their discretion in imposing that June 2021 sanction, and this 2021 2022, excuse me, order was well-reasoned and designed to protect both the Commonwealth and the defendant's interests here. And so it was tailored to cure any prejudice to the defendant, which in this case was essentially he was ready for trial in 2022, and the case was moved, on the emergency motion of the Commonwealth, completely at the behest of the Commonwealth at that point. But that order and sanction also allowed that Commonwealth to get their DNA testing that they wanted. They were afforded that opportunity to present their best case. And so it sort of is an issue of fairness at this point, where the Commonwealth did indeed get their DNA testing. Now they have that, and now if we were to go back on this, I think it's more of a Rule 14 sanction than Rule 36, but if we were to go back on that, the Commonwealth wouldn't suffer any sort of problem from having delayed unnecessarily getting that DNA testing, where there was no particular reason they could not have done that.
What about what about the sanction of excluding the Commonwealth's DNA results? I note that the first ADA on this case was intending to proceed without DNA results. So what about that?
Well, it seemed that the trial judge did consider that was in that 2022 order where she said, I'm totally within my right to exclude this, but I am going to not do that because I want the Commonwealth to have their best case.
Okay, well, and so assuming that we think that that's an overreach,
Right.
do you think that the judge would be correct that she could alternatively exclude the DNA?
Yes, I do.
Results.
Yeah, if the case is somehow reinstated through one means or another, I think that would be a perfectly fine alternative sanction in this case, because I think that would sort of go back to, it's a unique situation where the order is from 2022, but it really only came into effect, a little less than a year later, and here we are. So I think that would put us back to that place that case was in 2022.
What would be, we're in the dangerous land of hypotheticals right now, but
Right.
what would be the authority and the legal basis for excluding the DNA evidence on remand where the judge has already made a determination of no prejudice?
I think she made that determination, no prejudice, but she also then sort of did this whole Rule 36-esque sanction that does indicate that there would be some kind of prejudice to the defendant through this extension of, or moving the trial date. And so I would argue that the order sort of does find prejudice there in addition to not finding it. It's a bit of a messy order. So I think there's some tension there.
Do you think there's prejudice, regardless of whether the judge found it?
Right.
Do you think there's prejudice, and what is it?
I think it's kind of on that Rule 36. It's not a counting the clock situation, but I think it's that he was ready for trial, and the Commonwealth had their 2 years or so to get the DNA testing. They said at the final pretrial, no DNA, and then they changed their strategy right at the last minute in an emergency motion. So I think that essentially the prejudice is sort of extending from the continuation of the trial.
Well, since you raised Rule 36, let's talk about it.
Sure.
What is the precedent for a judge interpreting Rule 14 to, in effect, trump the provisions of Rule 36?
So I couldn't find any direct case on point. And so the precedent and where I come up with the judge's authority to do that is their broad powers under Rule 14 to craft remedies for situations. And so we're sort of using that language of Rule 36 under their broad discretion with Rule 14. So
Have you ever seen a case in Rule 36 where a defendant not only acquiesced to a continuance but sought it, and then a court imposed Rule 36, used Rule 36 to dismiss the case?
I have not, no, I don't.
I mean, my problem is, and I went through the the hearing transcripts. On November 25th of 2022, the Commonwealth reports ready for trial. Defense counsel asked for more time, which
Right.
he was allowed under the order. So they continue to January 25th, 2023 for status. On January 25th, it's represented to the court that discovery is complete. Both parties seek a continuance because they're still discussing a resolution, and the parties agree, let's continue to February 24th.
Right.
On February 2nd, perhaps the case was moved forward, defense counsel reports we're ready for trial and says to the judge, the indecent, which I assume is the indecent assault and battery, the case before us, the indecent, we're setting for trial for March 20th. Judge says, okay, March 20th for trial.
Right.
Defense counsel comes in on the day he sought and requested for trial and says, sorry, according to your order, Judge, too late for trial.
Right.
I mean, this is a legal term I'll use. It's called gotcha lawyering. Isn't that a problem?
I think in my response, I think just has to be, and it's also in the judge's ruling, it's not about a dispute over excludable times or not. I don't think it necessarily in this case can be, because certainly, yeah, that defense counsel had asked for more time. So I don't think counting the clock works for the defendant. So I think it goes back to the validity of that order back in 2022 and not kind of who asked for what time. That sort of, I think, has to be the defendant's argument here for this order to be upheld.
So it goes back to my earlier question, which is whether Rule 14 can in effect trump Rule 36.
I think, I don't know, trump isn't exactly the word I would use, but I think that the sanction, the judge's broad power to issue a sanction, kind of using the language of Rule 36, where I don't know if it's trumping it, we're just sort of importing the concepts from Rule 36 to this sanction. Yeah.
Right, but so picking up on that, right, I'm not adding much value, but the problem I have is that the delay here, Rule 36 is about unfair delay.
Right.
But the delay, so if we're importing the Rule 36 delay, it sounds like everybody agrees that really the delay here was for the benefit of the defendant and at the request of the defendant. Although the judge had initially said you've got a year, the defendant is saying, let me use that year to do other things that are helpful to the defense. So it feels as though that the defense is not complaining about the delay.
Right, yeah, they weren't complaining about the delay until after the March 17th. Right, I think it basically has to go back to the validity of the order, regardless of if the defendant is complaining about it or not. That essentially that order, and the order did make that clear that it was not going to be counted against the defendant, regardless of who asked for the continuance. So we are sort of resting everything on the validity of the order, which I'm using Rule 14 to prop up. So
final question for me, and
Sure.
I'm certainly sympathetic to the trial judge who tried to create, for lack of a better term, a creative solution here.
yeah.
But again, hypothetically, what other sanctions would be available at this point in time apart from dismissal and, let's say, for the sake of argument, apart from exclusion of the DNA evidence? I don't know if you've given that any thought, but I'm just curious.
I mean, my thought stopped sort of at what could we do different would be excluding the DNA evidence. I'm not sure what other sanction, kind of 2 years on now, would really even make sense. It's a bit messy, but I think, yeah, I'm just looking at it as we're going back to June 2022 and that sanction, putting ourselves in that shoes. And so that's where I'm thinking excluding the DNA evidence would be the most sensible sanction now. All right. Oh, no further questions. I'm happy to rest on my brief.
Thank you both for your helpful arguments, excellent briefing, and the case is submitted. Thank you. Calling our next case, docket 24454, Commonwealth v. Marin. hope I pronounced that correctly. But confident that Attorney Lynch will tell me.
May it please the court, Travis Lynch for the Commonwealth. With me is Attorney Kerry Kohler, who was the motion prosecutor below in this Commonwealth appeal. Our primary argument is that based solely on the facts that the judge specifically finds in his memorandum of decision, Sergeant Summers had reasonable suspicion.
I'm going to ask you to speak up, please.
Oh.
Thank you.
Sure, I apologize.
It's okay.
So just based upon, there we go, based solely upon the facts that are in the judge's findings, there's enough to get to reasonable suspicion to pat frisk the defendant without going into the possibility of appellate backbinding. Essentially, the defendant leaves this area of a shooting when after the police arrive. He gets out of a car after the officer follows him, and when the officer addresses him and says, "Hey, can I talk to you for a moment?" or something like that, the defendant then steps back onto the sidewalk, says, "I don't understand English." The officer says, "Well, do you have any weapons on you?" And then at that point, the defendant remains silent and, per the judge's findings, was staring at the sergeant. At that point, based upon the fact that this officer is responding to a shot spotter activation and the defendant is leaving the scene of the shooting and is evasive with the officer on the side of the street, there's a legitimate basis to believe that this defendant is armed and dangerous.
Well, he's leaving the radius of the shooting,
That's
correct?
correct.
The call came from shots fired, I believe, at 275 Main Street. And at 275 Main Street, there's a group of 10 to 15 people outside of a nightclub that's open, correct?
That is in the testimony, yes.
And the defendant came from an area that's within I'm not sure, a couple square block radius perhaps of 275 Main Street, is that correct? Something to that effect?
I think he's within the area.
What is the area? How wide is it? How big?
That might not have been completely clear, but I think he's in the area when it would be reasonable to believe that he was near where the shooting occurred.
Did the judge make findings as to the shot spotter area?
I don't believe.
I don't believe so
I don't
either.
believe he was that specific.
Did the judge make findings as to the reliability? I know there was testimony that it's reliable. Did the judge make findings as to the reliability of shot spotter?
He doesn't make findings specifically about the reliability of shot spotter, but I would argue that's not the issue at this hearing.
But he also didn't make findings regarding the fact that the Honda was the sole motor vehicle in the area. He didn't make findings regarding the eye contact. He didn't make findings regarding the car accelerating. He didn't make findings regarding the Honda accelerating in an unusual manner. No findings about the specification that the police were there within 1 minute, and then I think the second officer came within 3 minutes. So I'm saying all of that because it's pretty tough for us to evaluate whether or not there's reasonable suspicion here or not without those findings of fact. I mean, how do we possibly reverse the judge's determination where those findings aren't in the record before us?
My answer to that would be that the officer's credibility was not the issue at this hearing. The issue at the hearing was accepting what the officer said. There still isn't enough to pat frisk the defendant. That's the argument by the defense below. And I would say that it's telling in this case that even though the judge makes this finding about the shot spotter activation and that the police are responding to the shot spotter activation, it's there. He makes a finding that they're responding to a shot spotter activation, but he doesn't account for it in his legal conclusions. It seems as though the only thing that he really accounts for is Sergeant Summers saying, "I was nervous because he was staring at me and was silent." But there's all of that other evidence that's in the record. I don't think, the judge says he greatly credits the officer's testimony. I think he believed everything that he said.
Does it make a difference if the Honda's the only car that's moving in the area or not?
It does, yes. I think that would make it.
Well, what about the officer's testimony where he testified on direct examination that the car pulled out into traffic, but then on cross-examination, he arguably altered his testimony and said, no, it pulled out into the lane? Doesn't the judge have to resolve that inconsistency? Because under one interpretation, it's not the only car in the area. In the other one, it is. Again, without a finding of fact, we can't make that determination ourselves.
I agree that it's troublesome that there's a massive amount of evidence here. And if you believe what this officer says, there's reasonable suspicion, I would submit. And the judge's fact findings are extremely sparse. But even, I mean, he says that he believes what he says. He says it's not just I credit him. I greatly credit him. And it's not it's not a situation where the judge says, I'm prefacing the only things that I find to be fact is what I'm saying here. He doesn't say that. It's not, the fact finding is not particularly clear. But again, we would say, I think you could, we still submit that you can reverse. But in the alternative, the fact finding here is so sparse. And Attorney Kohler adduced a massive amount of evidence during this hearing that the judge just doesn't deal with. And again, the key fact here, the police are responding to a ShotSpotter activation and the defendant is leaving the general vicinity of a ShotSpotter activation. The judge just doesn't address that issue. He doesn't deal with it. And, you know, Torres Pagan's not, I know Justice Ditkoff knows about Torres Pagan as he was on the panel when it was an appeals court case, but Torres Pagan is not a shooting case. It's a traffic stop that escalates into a pet frisk. This is a shooting case.
I'm not sure that either precedent relied on by either party is directly on point. So I would agree with that.
Yes.
I mean, so if we accept all the testimony, we've got a shooting at a nightclub, and there's all these people standing outside the nightclub. Why is the guy who drives away the suspect? Why is that reasonable? Why not all the people standing in front of the nightclub where the shooting happened?
I would say that the fact that the person is leaving when the police arrives is an important factor, because invariably they're leaving because the police are arriving. That makes it more likely that that person is the person who did the shooting. Also, per Sergeant Summers' testimony, Sergeant Zerhide told him the driver looked at him and then drove off quickly. So it's not just that they're leaving, although that's important. They're leaving and the driver's looking back at.
Why isn't it a much more reasonable inference that they're leaving because there was just a shooting at a nightclub? It seems to me that that is an eminently sensible thing to do, to drive away, regardless of whether the police just arrived. Why does that count at all in the reasonable suspicion calculus?
My response to that idea is just because there's an innocent explanation for the defendant's actions doesn't mean that it doesn't count towards a reasonable suspicion. So the fact that there's another potentially innocent explanation for the defendant's actions doesn't mean that it doesn't count towards the officer's suspicion. Again, we have to consider the totality of the circumstances, and this is just one specific and articulable fact. The fact that I agree. I don't know why anyone is here I don't know why anyone is still there when the police arrive, but that doesn't mean that it doesn't count towards reasonable suspicion. It's also right before 2 o'clock in the morning in Holyoke, why anyone is out at that, I mean, you know.
Let me ask another question, I guess, on that same topic. You seem to think that it's important, or a basis for reasonable suspicion, that the defendant was staring at the officer after he asked him if he had weapons. The implication I think you were making was that the officer could consider staring at him after he asked, do you have a weapon, as suspicious. But I think the record is clear. He said right before that, I don't speak English. So it seems to me that the obvious inference there is, I don't understand what you're saying when you say, do you have a weapon? And so I'm going to stare at you. How is it reasonable to infer that that is somehow inculpatory?
Well, it's not, I don't think inculpatory is quite the right way to put it. The officer doesn't have to believe the defendant when he says, I don't understand English. That's crediting that assertion. I don't think that that's how reasonable suspicion works. For all the officer knows, he's lying to him about not understanding, and the staring is a prelude to him going for his waistband to draw a gun that he might have. The whole point of this exercise, allowing the officer to pat frisk people, is to make sure they're not armed, and if they are, to disarm them for officer safety purposes. So the fact that there's another possible innocent explanation for the defendant's actions does not defeat reasonable suspicion. And that fact is specifically credited by the judge in this case, the staring.
Do you agree that the finding here would have to be not only that he was, there's reasonable suspicion that he was armed, but that he was dangerous?
That is the standard.
Right.
Given that
And
there was a
so
shooting,
right.
that seems like a reasonable inference.
All right.
It's not just that there was a report that someone happened to have a gun. It was, there has been a shot that has been fired out there in the world, which means someone shot it. A person shot it inferably. That's the fear. I think you're much more dangerous if you're shooting a gun. It's different than if someone just said, so-and-so down the block has a gun with them, and they're not doing anything with it, I'm just telling you. That might not be enough to get you there to a pat frisk.
But presumably you don't think that the police should have been able to pat frisk the 15 to 20 people hanging out on the street outside the nightclub, right?
Not based upon what's in this record, because we don't really know. They're not doing anything on this record. We'd have no idea what those people are doing. Because this officer doesn't go pat frisk those people. Who knows what those people are doing? They're just standing there. So I don't think that, I would agree with the idea, just because you're in the vicinity of a shot spotter activation, you're not going to just be automatically pat frisked. There has to be more than that.
Okay.
So I think that that's sort of a concern lurking here in the background. But we have more things than the defendant just being there. Being there is very important, but we have more than that. There were suggestions about waiver in the defense brief. The prosecutor, Ms. Kohler, argued at the hearing the pat frisk standard. She says at page 60 in the hearing transcript, she says, I would suggest that interaction is more meaningful here and as opposed to Torres Pagan. Because of the interaction that Sergeant Zerhide had with the driver and the fact that the officers are responding to a shots fired call, that I would suggest gives them reasonable suspicion that the defendant is armed and dangerous. And at that point, the sergeant has the legal basis to pat frisk the defendant and seize that weapon. There's other facts that she marshals during her closing, but I don't think that the Commonwealth waives a reasonable suspicion argument by not making as fulsome a presentation of case examples. We're arguing the correct standard. We're arguing that it's reasonable suspicion. The Betancourt case that's cited by defense as an example of waiver was a case in which the Commonwealth initially tried to justify a search of the defendant by saying there was a legitimate investigatory purpose for that search. On appeal, having lost below, the Commonwealth changed tactics and said, no, it was actually community caretaking. That's not what's happening here. We've been saying consistently throughout, there's reasonable suspicion on the facts if you credit the officer. Again, our primary position is we think that there's enough on the judge's memorandum of decision, but given just the paucity of the judge's findings, but simultaneously saying that he greatly credits the officer, I don't think that this decision can stand. Unless there's any additional questions, I'd ask that you either reverse or you vacate and remand.
Thank you, counsel.
Thank you, Your Honor.
Attorney Fratto? Good morning.
Good morning, Your Honors. May it please the Court. My name is Cara Fratto, and I'm representing the appellee, Mr. PENA Marin. Speaking of the questions that posed to the Commonwealth regarding the reliability of the shot spotter, The Commonwealth didn't present much evidence at all regarding the reliability of the shot spotter. They presented evidence that this was a technology brand new to the city of Holyoke, about a month before this incident occurred. They presented no evidence as to the amount of times that the officers responded to a shot spotter in Holyoke, or this officer in particular, Sergeant Summers, or his responding to any shot spotters in this particular area. The sergeant had responded to prior calls to the area, but we have no evidence regarding the shot spotter. So we have a brand-new technology, about a month old, to the city of Holyoke. The officers arrived to a scene that sounds to be a very active scene. Bars, nightclubs, gas stations in the area, people outside on the sidewalk. Mr. PENA, Marin, and the driver were just two of a multitude of people in the area. We have no evidence as to them trying to conceal a weapon, running away, fleeing the scene, things that would give rise to reasonable suspicion. We have two people in a vehicle that drive off. Now, there's testimony that another officer...
The difference between driving off and fleeing the scene.
Excuse me?
What's the difference between driving off and fleeing the scene? You said they didn't flee the scene, they drove off. I'm not getting the difference.
When we look at the reasonable suspicion in the case law, we have fleeing the scene of people typically running, getting away, trying to evade police. Here we have people that were in a vehicle already and pulled out into the street.
Making eye contact with the police, and upon making eye contact with the police, pulling out, accelerating, and then accelerating more, and then accelerating yet again in an area where purportedly no one would accelerate. I mean, we have to look at it in the light, in the light most favorable to the Commonwealth, don't we?
Not in here. We have the motion judge made findings as to what happened there. The motion judge made findings that this vehicle was being followed to obtain its registration. It wasn't being followed because it accelerated out of there quickly. It wasn't being followed because of eye contact. We have nothing that says the judge made those findings about what the non-testifying officers saw. We have the Sergeant Summers who testified, and the judge is free to discredit or not make a finding as to what may have been told to him by a non-testifying officer when the Commonwealth played recordings of the interactions. And so therefore, the judge made the decision not to make that finding and made a finding that the Holyoke Police was responding to a shot spotter activation in that vicinity. And this car was being followed to obtain its registration. We have evidence that this car wasn't committing any traffic violations. And the argument that they were accelerating at an unusual rate of speed, it was within the speed limit. So there's nothing unusual about following the law. We have evidence here that we have no evidence that...
There was evidence that it was within the speed limit?
Well, they weren't committing any traffic violations. So the logical assumption from that is that is the speed that they were going within the speed limit.
What was do you have a transcript site for the basis for not committing any traffic violations?
I don't have the page number offhand, but Sergeant Summers' testimony at the motion indicated there were no traffic violations.
Thank you.
That he didn't cite them for any, or that there weren't any?
There weren't any.
Can I ask, sorry, I wanted to drill down on one thing, make sure I got this right. The first responding officer, who was not Sergeant Summers, instructed Sergeant Summers to follow the vehicle because, in order to get the registration. Is that right?
That is correct, right. And that is the finding that the motion judge made.
Oh, great. And is it a reasonable inference from that, for whatever it's worth, the first officer is thinking something along the lines of, I don't know what that guy's relationship to this is, but we're going to talk to these 15 to 20 people out here, and if any one of them says, oh yeah, the shots came from that car, then we at least know where that guy is. Is that Is that a reasonable inference? Is there anything in the record that contradicts that?
There's nothing that contradicts that, and I believe that's reasonable to want to know who was there.
Right. And so my point, I guess, is it a reasonable inference from that Summers was not following these people because of a reasonable suspicion that they had shot this gun, but rather he's being told by the other guy to go do that, and we'll see what transpires?
Yes, I believe that's exactly what the record showed, and it seems to be what the motion judge found, saying that they were being followed to obtain the registration.
Thank you.
In turning to the arguments regarding the sidewalk interaction, the Commonwealth writes in its brief that the facts leading up to the sidewalk interaction alone weren't enough to go up and pat frisk Mr. PENA Marin, which is why the Commonwealth, presumably why at the motion hearing, the Commonwealth was really trying to hang its hat, quoting their argument on the Mata case, trying to argue that the interaction was odd to the point of reasonable suspicion. But what we really have is the driver had pulled over to let Mr. PENA Marin out. He gets out, and that's when Sergeant Summers approaches him. Lights are on, approaches him, "Can I talk to you?" Defendant turns around, steps onto the sidewalk, indicates he doesn't speak English, keeps his hands visible, and is looking at the officer, or the sergeant. Makes no furtive gestures, isn't acting, we have no evidence that he's acting in a way as to conceal his waistband or conceal a weapon. He's not fleeing, at that point he's not fleeing, he's stopping, and he's, making himself visible, his hands are visible, he's not a threat. And Sergeant Summers immediately goes up to him and frisks him. Trying to argue that he was nervous because he is leaving a scene of a shooting. We don't have any evidence that there was an actual shooting. We have an evidence of a brand new technology saying that there was a shot spotter activation. If we look at different case law in Massachusetts, these shot spotter activations need to be combined with more. If we look at the case I had put in the 16L motion, letter, is a Federal District of New Mexico case, United States v. Vallow, which analogizes a shot spotter activation to an anonymous tip. And there needed to be much more than just the proximity and being in the location of the shot spotter activation.
But in that case, there was a 10-minute delay before the officers arrived on scene as opposed to a 60 to 90-second arrival. And in that case, there was also no flight from the scene.
Correct, but this wasn't necessarily a flight from the scene. It could just be people leaving to go home. After being out at the bar. We have nothing here.
That's one possible interpretation. Again, we don't have the judge's finding of fact on that, so this court doesn't know.
Correct, but what we also don't have is anybody at the scene acting as if shots were just fired as well. We have nobody acting in a panic, nobody, flagging down an officer saying over there, or shots, or no 911 calls coming in, independently verifying that they heard a shot, such as some of the Commonwealth's cases that they had cited, such as Ford and Nimmer, that there were shot spotter activations leading only to one person in a deserted area, in a residential area. This wasn't a shot spotter activation leading only to this one person. There was a multitude of people around, and that them being in the area, then driving from the area, and stopping and taking a step onto a sidewalk where he was going, and looking at the officer, keeping his hands shown, staying visible, not making any furtive gestures, not trying to conceal a weapon. There was nothing reasonable that would give rise to a reasonable suspicion that he was armed and dangerous, justifying the immediate pat frisk of this individual. The Commonwealth, even in its arguments and its briefs, continuously says the scene of a shooting, the scene of a shooting. But we don't have any evidence that there was actually a shooting. We have evidence that they were investigating shots fired, shot spotter activation, possible. Nothing that independently verifies, nothing that corroborates that. We have evidence and findings that this car was being followed for its registration. Hadn't done anything to warrant reasonable suspicion that these people or this particular defendant was armed and dangerous, the Commonwealth concedes as much in its brief. And then trying to add that just by looking at the officer, keeping his hands visible, staying still, cooperative, is automatic rise to immediately pat frisking on the sidewalk, that there is not enough here for the Commonwealth to have met its burden below. The judge made the findings based off of what was presented, based off of the testifying officer, and the facts that came out, and the judge made those findings there. The Commonwealth seems to be upset that the non-testifying officer's credibility was not put into the findings. The Commonwealth had asked in its brief for a remand for further findings, and we'd ask that you deny that request for a remand here. The Commonwealth had its chance, did not fully litigate the case, did not fully bring out all the facts that it wishes this court or the motion judge to have to find, and would wish to go back to the motion court for another bite at the apple here. And we're asking that this be denied. The Commonwealth waived its rights to fully litigate this case when they rested their case. They rested, as Justice Neyman had said, that you don't believe that the cases, or even the matter, were controlling here. And I would agree that that case wasn't a controlling case in this matter, and that the Commonwealth declined to submit any post-hearing memorandums and waived its right to have any further arguments or any further evidence presented. And we would ask that you uphold the motion judge's findings, uphold the decision, and affirm the allowance of the motion to suppress.
See if there are any further questions. Seeing none, thank you both.
Thank you.
Well presented, and the case is submitted. We're going to take a 5-minute recess.
Court is open. Please be seated.
Well, we said 5-minute recess. We pretty much kept to it. So calling our next case on the docket, 24-634, Department of Children and Families versus Mother. I would remind everyone that this case is impounded. Please refrain from referencing any names in this case or any other impounded information. We'll hear from counsel for the mother, Attorney Packin.
Thank you. Members of the panel, may it please the court, Nicole Paquin on behalf of the appellant mother who is present in the courtroom today. Mother asks that this panel vacate the order finding her unfit and to remand this matter for further proceedings before a different judge in the juvenile court. Mother was deprived of substantial grounds of defense by her trial attorney's unreasonable and ineffective assistance, which fell far below that of an ordinary lawyer at trial in this case. At the trial and at the subsequent hearing on Mother's motion for a new trial, the trial attorney attempted to excuse his behavior by portraying Mother as uncooperative and unfocused, when in fact she had actually completed the few tasks that he gave her to do. She had signed releases so that the trial attorney could obtain drug screening records. She completed a psychological evaluation, and she drafted a statement at his request, at his advice, for her to read to court. Now, that statement is another example of this trial attorney's ineffective assistance. Instead of preparing Mother for direct and cross-examination, instead of explaining to her the scope and relevance of questioning, he instructed her to draft a statement to read to the judge. At the hearing on Mother's motion for a new trial, he tried to explain this by saying it was not supposed to be testimony. It was just supposed to be addressing the court at the end of the trial. And that's transcript page 296.
So I'm more interested in the prejudice prong of this claim.
Absolutely. So these errors cumulatively in the totality of the circumstances were prejudicial. The findings made by this judge repeatedly found Mom not credible, attacked her willingness to engage with the department and complete action plan tasks, criticized her perspective and understanding of her parenting role. And these failures by the trial attorney deprived her of the ability to have evidence that corroborated the limited testimony that did get in at trial. This evidence that was not in would have corroborated that she did take steps, that she was engaged, that she had cooperated with the department successfully in the past, had undergone some therapy during the pendency of this case. And overall, for example, just, because again, I think there's not one piece of evidence that was the most critical, but when you look at the full picture, the prejudice is there. For example, the trial judge ultimately found that Mother's sending her children to the aunt's home was unparental behavior, and he criticized her for that decision. But Mother,
the judge credited her for sending the children to that home.
In conclusion 6, the judge calls that unparental behavior. And so she's criticized for doing what she believed to be right in accordance with the safety plan. The testimony at trial is very unclear as to whether the safety plan actually existed.
Conclusion 6 is apparent to the court that Mother feels she is being punished. That is not so, as this case has revolved around protecting the endangered children, names them. The record is replete with instances of Mother's unparental behavior from her volatile relationship with boyfriend through July 4th, 2021. I don't see anything in there that says it's unparental to send the children to the care of a responsible caregiver.
So when she mentions through the July 4th, 2021 incident, that is the day on which she sent her children to the aunt. That is the incident. So on July 4th, 2021, mother was at home with her children. She was attempting to work through difficulties with a roommate, have the roommate move out. The roommate was not agreeing to that, and she sent her children to a predetermined safe caregiver, which is the sister. And so on July 4th, 2021, that incident is when she sent the children to the aunt. The prejudice, excuse me, also the evidence that, the documents that were not in evidence or not used to cross-examine witnesses, it contained information that mother had tested negative for alcohol, although the testimony at trial was extremely unclear as to whether mother had even been tested for alcohol use. And historically, the department's primary concern in this case had been mother's use of alcohol. That was the overriding concern for much of this case. And at trial, it was extremely unclear whether mother had even been tested for alcohol use, prompting the department's attorney to question whether the attorneys were just going to leave that topic as it was.
But
go ahead.
These screens seem to only test like a breathalyzer, whether she is intoxicated at the time that she comes to take the screens, not sort of like a have you drunk in the last month kind of test, right?
So that is not really clear in the evidence. The probation officer did discuss that they tested for a certain threshold. That was in her testimony. But what exactly that alcohol screen was looking for was not really fleshed out on the record. Most screens...
But it says on the screens they're looking for what's the equivalent of about a 0.05 BAC, right?
Yes. So most screens look for present use. And that is the role of the screen. But the fact that mother was tested and did come, and those tests were negative, was never introduced into evidence. And again, I think this is just one small piece that overall, you know,
I guess the concern I have is the same as I think with the prejudice prong. You know, this case really turns on the evidence, the children reporting that mother abused them when she was under the influence of alcohol. And except for the substance use evaluation, I'm not seeing how any of this evidence goes to that key problem. And so if you think it does, I mean, obviously the substance use evaluation is different, but if you think it does, please explain it to me.
So I think the unfitness was, in the unfitness calculation, it's not just about the children's allegations of this emotional abuse. It's also, you know, the judge considers whether mom has been cooperative, right? Whether mom has taken strides to become a better parent, right? Whether she's addressed certain concerns. And all of that gets lost because her trial attorney did not elicit that information. Instead, the trial attorney asked her questions that led to some of the most damaging testimony at trial, right? Mother's own testimony could have been compelling, but she was deprived of that because she was not prepared to testify, right? Even
but on this, I think this is a useful example that you've chosen, his treatment of evidence about substance abuse. I think it's indisputable, whatever they're testing for on the levels of alcohol, there are two things that I took away. One, 5 positive tests for meth after this July 9th DCF initiation, and which were confirmed because she was denying it. And then secondly, after those 5, she stops showing up for these screens. Have I got that right factually?
Factually, that is correct.
Right, and so I think what they'll say is that trial counsel had a perfectly reasonable tactical basis for this, not emphasizing these tests because they were bad. And so if he says anything about substance abuse, those are the first 2 things that will be the response. How is that not reasonable?
Because all of that bad information was already in evidence. and he could have highlighted the good evidence. Even if he didn't seek to admit those records into evidence, he could have used them to cross-examine a social worker or the probation officer about the negative alcohol screens. I agree, that damaging evidence was there, but this trial attorney had evidence that supported mom's defense, and he ignored it. And so he let the negative evidence sit in evidence and did nothing to rebut that with the positive evidence that did exist.
Thank you.
There's also the issue of the motion for new trial. So the trial attorney's testimony at the hearing for motion for new trial was contradicted not only by his own earlier affidavit, but also by the testimony of Mr. Marin, who completed the psychological evaluation, and Mr. Marin, who completed the substance use evaluation, and Ms. Wood, who completed the psychological evaluation, right? The hearing judge, who was not the same as the trial judge, the hearing judge ignored without comment the fact that trial attorney's explanation as to why he did not call these two witnesses at trial were contradicted by those witnesses. So regarding the substance use evaluation, the individual, Mr. Marin, who completed that evaluation, he testified that that trial attorney had never spoken to him about possibly testifying, right, which is contrary to the trial attorney's argument that he had spoken to this individual and that he had some strategic reasons for not calling him. Mr. Marin specifically testified at the hearing that he had never spoken to that trial attorney, and the hearing judge did not even comment on that contradiction.
I just want to make sure I'm understanding this as well. His evaluation was before the positive meth screens, right?
Correct.
And if he had, and I hear what you're saying, that trial counsel said we talked, and Marin said, no, we didn't talk. I don't know what he's talking about. He's lying. I get that. That seems plausible. But nevertheless, back to prejudice, he would, if he had taken the stand, and I understand, he would have said, I saw no evidence of alcohol abuse. That's helpful on alcohol. I get that too. But the cross-examination, not subtle, would have been, were you aware of the 5 meth results after that? Were you aware that after that she stopped taking these tests? Let's assume, well, wouldn't that have dramatically undermined his testimony?
I imagine that if he were actually called at trial, as Marin testified at the hearing, he would have had further interactions with mother prior to trial so that his testimony was current. Right, there would have been follow-up to this substance use evaluation, which was not done, and we don't know what that would have led to because the trial attorney did not take those steps. Right. And again, Wood, who authored an affidavit, also said that her testimony at trial would have been consistent with her report, that mother was fully cooperative with the psychological evaluation that she conducted. The trial attorney testified that he had spoken to Wood, and Wood said that mother was uncooperative and that her testimony would have been different than her report, that it would have been negative, it would have been harmful to mother, and that's why the trial attorney didn't call her. But again, that's contradicted by an unbiased witness's affidavit, and again, the hearing judge did not comment on those conflicts. And so we don't know that the trial judge found the trial attorney particularly credible, or if she just missed this contradiction in the record.
Could I do ask, want to point, sorry, just very quickly, this was new counsel at the evidentiary hearing on the new trial motion, could counsel have called Ms. Wood to testify?
Counsel could have called, well, Wood is, it's outside of the record, Your Honor. I represented mother at that hearing. I can, but it's outside the record.
Okay. I understand. We're not allowed to
I believe
speculate.
what's in the record is that Wood is in New Hampshire. And so with the state line and scheduling.
Well, let me ask a different question very quickly. Based on the evidentiary rules that apply in this context, was the judge permitted to consider Ms. Wood's affidavit, which I'm aware of, I understand what you're saying, that she contradicted a lot of other people. Was he allowed to, he or she, the judge, allowed to consider that, and the lack of cross-examination, how would that have shaken out?
Yes, I believe she could have considered the affidavit and given it whatever weight she chose to do so. The the hearing judge does not appear to have considered it at all.
Were any of the affidavits put into evidence at the hearing?
No, they were submitted as part of the motion packet.
But were they agreed as evidence, agreed as exhibits?
They were not submitted as affirmative exhibits at the hearing.
I have a few more.
Please.
Your friend, I'm going to ask your friend, you say your friend's justice could be moot, and you argue compellingly that the findings could be evidence in a new hearing. If your friend, and I have no reason to think your friend's going to say this, but if your friend says, no, I agree, I won't introduce the findings, is it still not moot?
I find it difficult that my friend would say that. I would be concerned about information about this case that is already in the judge's knowledge carrying over into the a new review and redetermination hearing. I think because of the nature of the ineffective assistance of counsel, it tainted so much of the evidence and the findings that I don't think just simply having counsel agree that they're not going to seek to admit them. I'm not sure, as I stand here, whether that would preclude the judge from considering them anyways. And I'm not sure. I think I would be concerned that that taint from the ineffective assistance of counsel would continue anyways.
And that kind of leads into my final question, which is you've asked us to disqualify the judge on remand. Why?
Because of the nature of the findings, the trial judge and the hearing judge both upheld these findings that are...
The trial judge is retired, so we don't have to worry about him.
He's no longer in the picture, but the hearing judge is still a sitting judge. And given her understanding of this case, I think the ineffective assistance of counsel has, because the findings of the trial judge were so focused on the mother's character, if you will, about not taking responsibility, not engaging, not prioritizing the children's needs. This was not a case where it was just about the mother's behavior. It was also about her willingness to engage and her temperament. And a lot of that was due, again, to the lack of corroborating evidence because of a trial counsel's ineffective assistance of counsel. So the concern is that once you have that impression of the mother, how does a trial judge put that aside? And that's why we have requested a different judge.
Justice Ditkoff, anything further?
Thank you.
No. Thank you very much, counsel. We appreciate
you.
the argument, and we'll now hear from first counsel for the department. And could you remind us how you're dividing your time, please?
Yes, I will take 7 minutes and then 4 minutes each for Children's Counsel.
Thank you.
May it please the court, Lynn Murphy for the Department of Children and Families. As this court knows, this case involves a permanent custody order, finding mother unfit by overwhelming evidence. We have a situation and a pattern of behavior that developed over 4 to 5 years. We have significant substance abuse and mental health issues. The mother was given numerous opportunities to correct this behavior and at times was somewhat successful in obtaining services, which gave the department hope that she could continue to parent these children. Over the years, it became obvious that this was not the case. And at the final CMP, when the court decided, the department decided that We needed to have a permanency.
The judge at the beginning, the trial judge, at the beginning of the hearing says, not a termination case.
Right.
Was that something the judge had decided, or was that the way DCF was
No, that's the
proceeding?
department. The department only wanted, I think what happens is sometimes these cases, they linger, and then you don't have an unfitness finding. And the judge was concerned, and this is one of the reasons why the judge wouldn't allow the continuance. You're talking about over a year. I think it was 14, 15 months. And there's no adjudication before the court. And the judge explained to mother, look, this is what the department needs to show, your unfitness. This is actually going to benefit you. You can tell me why that's not true. You can get custody back if you're fit. And then even when the order issues, then there is the review and redetermination kicks in. There's other things that the parent can do at that point. So I think that the judge was very worried or cognizant of this situation with no finding of unfitness. So the department moved forward, and the judge wisely held the trial. And then the evidence of unfitness was very clear during that trial. As far as the ineffective assistance of counsel, the evidence you're hearing afterward, after the motion was filed, shows that this attorney made numerous strategic decisions to keep more negative evidence from getting before the judge. Again, substance abuse and mental health were the big issues in this case. If he had let this other information in, this would have given the department numerous opportunities to emphasize that mother's substance abuse continued up until trial, as seen in the positive screens.
Well, how do you respond to Attorney Paquin's argument that the cat was already out of the bag? This information was already before the judge, so there was so much more to gain by stressing the positives because the negatives were already out there.
Not sure there were any positives to stress, except possibly that mother complied when her attorney asked her to do an evaluation. She did so. That was the only positive. And
passed the alcohol tests, or did not fail them at the time.
Yes, but given the methamphetamine positives, that greatly outweighed.
Let me ask you about that. Obviously, I've focused on it. The mother's attorney makes the point, which seems reasonable, that this occurs after the children are out of the house, and so the argument would be this didn't happen around the kids. It had no impact on the kids. It had no impact on her fitness as a mother.
Oh, it had an impact on her fitness because we've had substance abuse problems for 5 years, and having those positive tests months before trial showed that this was not resolved, that this was a current issue, and that it was even more, possibly more concerning. And here we have mother on the stand saying, oh, not only do I not, well, maybe alcohol has been an issue for me, but I haven't done any other drugs, I'm not, except for my marijuana to help me calm down and deal with my mental health issues. It would not admit that she tested positive on 5 occasions, not even one occasion, 5. And those results were confirmed, again, by mother's counsel. So there was definitely, I think there was, the trial attorney was very reasonable in not bringing all this information. And then, as we know, the medical history, mental health history, the attorney was very concerned that there would be a mood disorder because mother had told that evaluator, no, I didn't take meth, so that's not true. So once that was confirmed through those, again, now we have the actual tests being entered into evidence, and once the department had those records, they could, double down, so to speak.
I do want to drill on that for 1 second. I think I've read all this notion that Ms. Wood might say, was about to say, that the mother had a mood disorder, maybe had a mood disorder. That to me, as far as I could tell, well, first of all, Ms. Wood's affidavit says, no, I didn't say anything like that. But this, I think, comes, and please correct me if I'm wrong, entirely from trial counsel for the mother. This notion that I was worried that Ms. Wood, in fact, did say, if I examine her again, I'm worried I'll find a mood disorder. That, to me, made up out of a whole cloth, unless I'm missing something in the record.
No, I think the report is in evidence. The report
Okay,
that
so-
she
okay,
wrote,
so-
and there's a paragraph in there where she says, mother denied using methamphetamines, and I can't remember the exact wordage, but something to the effect, if this were not the case, I would be concerned about a potential mood disorder and an ability to make judgment calls. So you can see why the
Okay, I see.
trial attorney was very leery to go down that path.
Okay, thank you.
Because it would make the mental health issues even more pronounced. If there are no further questions, I will rely
Well,
on
so
my
there's
brief.
the one prophesized question, which is, do you intend to introduce the findings in the next hearing?
As you know, adoption of Simone and adoption of Paula instruct the department that it is the better practice not to enter findings and conclusions that are under appellate review. So we would not be doing that.
Assuming we haven't ruled yet, you're saying?
Well, what happened in this case is we did have an R&R scheduled for December, but the judge was concerned about this case and the outcome of this case, so she has put it off. So we're not going to have an issue. She's put it off till March.
Okay, thank you.
Okay, thank you.
Thank you very much.
Counsel for Child 1.
Good morning. May it please the court, Sheila Tierney on behalf of the appellee daughter. First, I would like to address the question that Justice Ditkoff asked of mother's attorney when Justice Ditkoff inquired, didn't the trial attorney commend mother for sending the children after the July 4th, 2021 incident at the house to maternal aunt's house? And in fact, in the judge's finding number 103, the trial judge stated, and I quote, the trial judge discusses what happened on that July 4, 2021, and does say, and I quote, while mother made the responsible decision to ensure the children were sent to her sister's house, he then goes on to reference that mother put responsibility on my client to contact the maternal aunt, and also the fact that mother apparently employed a friend who mother admitted had lots of problems to actually transport the children that night. But there is, in fact, finding that the judge did give mother credit for acting responsibly on July 4th and having the children removed from the household. I'd like to spend the remainder of my time addressing why the trial judge correctly found that mother was unfit at the time of trial in order to parent the children. And the judge found that, and I would argue at the heart of this case, is overwhelming evidence of mother's established pattern of misusing alcohol, engaging in volatile behavior, participating in arguments, including some arguments that were violent in nature, all of which created a chaotic environment which jeopardized my client's physical and emotional well-being. While mother repeatedly denied any substance misuse and denied that her parenting was impacted by her substance misuse, there are 3 significant instances in the record that completely refute mother's statements. I am referring to the first incident, which was in March of 2018, when mother was chasing her then boyfriend around the kitchen of the household and assaulted him with a coffee cup, which resulted in significant injuries to him. My client, who was 10 years old at the time, witnessed this assault. Not only did she witness the assault, but mother's boyfriend told the DCF investigators that he had actually asked the child to assist him in trying to control mother's behavior. My client asked her mother to stop. Mother yelled at her and continued to assault the boyfriend. Mother continued to engage in inappropriate behavior when the police arrived, which led to her being arrested, and my client indicating throughout the time that she was questioned about this incident, including to the court investigator, that she was really scared by this incident. We then had the incident in November.
You only have 30 seconds left, so rather than get into the facts, the details of the case, why don't you just point us to the finding of fact number that you want us to look at, if that might be a better use of your time, the remaining time.
I would point you to finding of fact 52, finding of fact 48, findings of fact 67 through 71, 75, 77, and I would also indicate that throughout, Mother was never able to acknowledge that her substance misuse impacted her parenting, and she blamed everyone else, including my client, for her issues.
Let me check to see if there's any further questions. Okay, seeing none, thank you, counsel.
Thank you, Your Honor.
Good morning. Susan Taylor for appellee number 2. On behalf of my client, I think that it's easy to lose sight of the fact that the hearing in this case in which Mother was found unfit occurred in October of 2022. And the evidence in October of 2022 is that the department proved by clear and convincing evidence that this mother was unfit, that she suffered from untreated mental illness, that there was substance abuse issues, and that there were incidents of domestic violence that were ongoing that occurred in front of these children. Now, the first 51A in this case happened when my client was 3 years old. He was removed from Mother's care when he was 9 years old. He is now 11 years old. He has been in 4 different placements since his removal. He has an IEP, and he's diagnosed with anxiety, depression, and self-harm. There was clear and convincing evidence in this case that Mother's conduct and fitness were such that my client was put at risk for serious emotional harm. With regard to the motion for a new trial, it's quite clear that Mother, if you look at the record, that Mother has had 6 different lawyers. This particular lawyer was appointed 2 months before the trial and moved to withdraw shortly before the trial. The fact that this appeal was filed after the court found her unfit, and the irony being that a finding of unfitness is not a final permanent order. Mother could come back to court in 6 months and petition the court to have her children returned, that she can say, I'm now fit. But instead, for the last 2 years, we've been litigating this appeal. And certainly Mother's counsel in her reply brief indicate that Mother has every right, and Mother has every right to litigate this appeal. But this appeal and the motion for a new trial are symptomatic of Mother's inability to simply comply with an action plan and establish to the court that she's fit. She was unfit in October of 2022, and we don't really know if she's fit today. Perhaps she is. Maybe when we go to court in March, she will establish that she is. But there's no merit to her claim that the trial judge abused his discretion in determining she was unfit or in denying the motion for a new trial. And I'd ask the court to so find.
Thank you, counsel.
Thank you.
These are difficult cases. Want to acknowledge the thorough arguments of counsel for the mother, counsel for the children, counsel for the department, as well as the very thorough briefing. We'll take the case under advisement, and the case is submitted. Thank you. Calling our final case on the list today are cases 23P 1304 and 1305, Hoyland v. Town of Wellfleet Conservation Commission.
May it please the Court. Thomas Moriarty for James H. Hoyland, trustee. This is on an appeal from a judge's denial of plaintiff's motion for judgment on the pleadings. The first point we'll address is with regard to the second decision that was issued by Justice Callan.
Before you get there,
Of course, Your Honor.
there's a lot of meat on this bone, so let's see if we can pare this down a little bit.
There is, Your Honor.
Is the first appeal, is it moot, for lack of a better term? And when I say that, is it moot while acknowledging that everything that is in the record before us today, in the record appendix and in the record on this case, properly preserved, not waived, with that predicate in mind, is the first appeal moot?
With that predicate in mind, we could concede that the first appeal were moot. We would treat this essentially as a jurisdictional issue. The trial court preserved jurisdiction essentially in connection with the remand. The only reason for the further complaint, that is the second complaint, is because of the procedural requirements associated with the certiorari.
That's my understanding as well, and if we get the same acknowledgement from sister counsel, then we'll be able to at least know what the playing field is. But go ahead.
Thank you, Your Honor. The second decision is clearly erroneous. The remand in this case was for a limited purpose, to review the project on the record, which the Conservation Commission clearly did not do, and to ascertain whether the project satisfied the requirements of Section 2.03(4)(a)(2).
Sorry, I just have to jump in.
Of course.
I really could not get my head around this fundamental foundational concept, which seems to be at the very essence of your argument, that at this second hearing, the Commission, trying to determine what's in the public interest, should not be allowed to consider new evidence. First of all, is that assertion a fair characterization of your position?
Absolutely, Your Honor.
Okay, so to help me understand why it's bad public policy to permit a public commission to prohibit that commission from considering new information.
Because there is a public policy on both sides of the V in this instance, Your Honor. There is a public policy that surrounds the process by which a property owner, desirous of protecting its real property, has the opportunity to submit evidence to a Conservation Commission and the Conservation Commission's ability to receive that evidence. It's the applicant's position in this case that really what has occurred is not a function of a Conservation Commission as a neutral arbiter of evidence as produced by the applicant. The Conservation Commission had every opportunity to request additional information at the first hearing. It did so. In fact, there's no suggestion the applicant did not comply 100% with the request for additional information made of it by the Conservation Commission. What the law does not allow is for a Conservation Commission to act as an opponent to a project. And that is precisely what happened in this circumstance by the Conservation Commission itself seeking out and obtaining information after the fact to support a decision. That would be the equivalent of saying that a court had the ability to go outside the process and to obtain additional information as an advocate for its own
Before
position.
they issued their second decision, hadn't they already been made aware, not by going out and looking for it, but by you bringing to them the soft solution that was tried?
Your Honor, the soft solution was introduced not in the context of this proceeding, but introduced in order to save the property in the interim.
But you're saying they went out and looked for that, but it was actually brought to them, right?
No, that's not the only information that the Conservation Commission relied on, but it was not brought to them in the context of this proceeding. this is not simply putting form over substance. There are meaningful property interests that were implicated at the time that the applicant submitted its request or its notice of intent for this activity. There is a process that is in place that guarantees not just the public interest, but the private property interest against which these questions are being balanced. So
Can I just drill down on something you said? I've already forgotten the exact quote, and I apologize. But they went out looking for, the commission, went out looking for additional information. I think the chronology is important here. My impression of the record was that at the second hearing, they got lots of testimony, including from the Department, or at least a letter from the Department of Interior. Organizations, government agencies that had a knowledge and interest and expertise in these important environmental issues. Are you suggesting that they obtained any of that information after the hearing? Or because my impression from the record was that that information came in at the hearing.
2 points to make, Your Honor. I have to challenge the court's characterization of Mr. Carlson as an expert. There is no evidence in the record that the mere fact that this person was a superintendent of the Cape Cod National Seashore, that he had any particularized expertise whatsoever with regard to sediment transfer, with regard to any of the technical issues that were presented to the Concom. Clearly, there was, as an abutter, an interest possessed by the Cape Cod National Seashore, which goes back decades with regard to this property, quite frankly. But, Your Honor, the pivotal question is, did they obtain that information before or after the first Conservation Commission hearing?
Right, and but let's just humor me. Let's just say I disagree with you about that. I can understand a due process interest in notice. So therefore, I can understand an unfairness argument if this commission went out and got information after the second hearing. But assuming you're adopting my due process model, just humor me, answer my question. Did that happen? Did they get any of the information they relied on at the second hearing come after they made their finding on the date of the hearing?
No, Your Honor. That would have been at the hearing.
Thank you.
So, and the applicant would concede, if the court disagrees with the scope of the remand that was established by Judge Perino, that our arguments would now be relegated to the question of whether or not there was substantial evidence at the second proceeding. So there's no question the applicant focuses on the propriety of the remand in the first instance. It is the trial court that set the parameters of that remand. It was not, regardless of how you would assess the public policy in a vacuum, it was not to the Conservation Commission or up to the Conservation Commission to ignore the scope of the remand that was established by the trial court.
So I have another question. We're the appeals court. And so if we think that the first judge, Judge Perino, was wrong to do that, is there any authority that we're somehow precluded from saying he was wrong to limit, assuming that is what he did, and I don't think it's so clear that is what he did, but let's say that he restricted them in the way that the commission, in the way that you're saying. Are we precluded from saying that was wrong?
No, Your Honor. This court is not precluded from evaluating the propriety of that decision. Okay. There is a question, and it's
because our review is de novo, is that why?
So that's the question, Your Honor. It is clearly de novo, and this is an appeal on certiorari, is clearly de novo with regard to the merits of the underlying determination. What we don't have is a case that answers the question of whether the subsidiary directives that were provided by the trial court to the Conservation Commission, where it didn't come up, it went back to the Conservation Commission, whether that is de novo, whether it is a clearly erroneous standard. We've argued it as a clearly erroneous standard, but we do concede that this court, if this is the way the applicant would approach it, we don't ask for a remand. We ask the court to make a determination because the Conservation Commission has had the opportunity to comply once with a very clear remand that said, consider the record as it exists, and it's a pre-August 10th, 1978 structure, which the Conservation Commission did comply with. But if there is to be a remand, the applicant believes that it is essential that this court make a determination as to whether or not the scope of the remand as established by the trial court was proper. So we have said that we do not want there to be a remand because
Let me ask you this, because a lot of time has gone by. If we agree with Judge Callan and the commission that this is a post-78 building, is that it? Does your client lose, or is there still an argument if we get there?
So technically, your argument, the argument would be that there would be an argument available, but it would not be successful. And the reason I can say that with confidence is that the standard that is applied under 2.03 4A1 is that the CES be demonstrated not to reduce the ability of the coastal bank to replenish downstream sand. The nature of the CES is to prevent any further erosion of the coastal bank. So we would concede that it's not possible to do so. Now,
Otherwise said, this case hinges on the analysis, for you to succeed, this case hinges on the analysis being under sub 2 rather than under sub 1.
Correct, Your Honor.
Okay, that's
and
my
what's significant is that Judge Callan made a determination, erroneously we say, because it did not recognize the reconsideration that Justice Perino had made of his own decision. And I know, Justice Wood, you indicated that you might not be convinced about the limited scope with regard to considering the record. On that decision on reconsideration, was called a decision on the motion to vacate because it was combined. But on the reconsideration decision, the court clearly said the record was sufficient at the time of the original hearing. And in fact, Justice Gildea, in his further order where he vacated the judgment, that is paper number 26, not the remand order, which was paper number 25, he again reiterated that there was a determination with regard to the date of the existence of the structure.
Does the current structure in any way share the same footprint as the pre-1978 structure? Looking at the schematics, it looked like it does not, but I don't know that.
Could there be overlap on the footprint? That I can't say, but the applicant would concede that this is a reconstructed building. I mean, it is a new building, that the foundations, the helical piles, the exterior envelope, roof, et cetera. At most, there could be some overlapping of the footprint, but I can't say one way or the other, Your Honor. But we don't suggest that it is essentially an extension of the earlier structure. What's significant from the applicant's perspective is that the Conservation has not treated this structure as a post-August 10th, 1978 structure in the past. In a 2007 decision that was issued by the Conservation Commission.
Because it didn't issue the,
it did not include the statement under Section 310 CMR.
Right. I think we know where you're going. But on that point, the Commission's attorney makes a very good argument that I hadn't appreciated until I read it, that requirement comes from the CMRs. And stop me if I've got this wrong, but the bylaw which is created by the town of Wellfleet, has no such requirement. And the town of Wellfleet doesn't understand the reason for that CMR flag, which is, I guess, a consumer protection. So if you're going to buy this big place on the water, beware, you're not going to be able to get an OOC for a CES and stop erosion. But for the town, they don't care because they are just protecting their area. I don't think you responded to that argument in your reply brief. Am I wrong?
Well, we may not have responded to that argument. Perhaps we didn't give it as much value, Your Honor, because the law is very clear. A Conservation Commission can be more restrictive with regard to the enforcement of wetlands regulations adopted through a bylaw in the municipality. It can't ignore the edicts of the Wetlands Protection Act.
1035 says you're supposed to put in a condition that says 310 CMR 1033 requires that no coastal engineering structure will be allowed. But how could the town have put that as an order of condition in 2010 or 2007 when 310 CMR 1033 doesn't require that?
Your Honor,
It requires it as the bylaw, and that's not what this regulation says. It says, under certain circumstances, to say that state regulation
But the Conservation Commission derives all of its power and authority to issue either an order of conditions or a certificate of compliance through the state statute. So they have to comply with WPA in that regard.
Can I ask one more question?
Yeah, although your time is up, I'm going to give you a few more minutes, so go ahead.
Thank you, Justice Neyman. The only public policy I could find was on this requirement of notice is that it interferes with your alienability rights selling the place to the next person. But here it seems like that concern is not really at the fore because there's no claim that the trust is looking to sell the place. They're just trying to get their CES to protect their property. So I don't see, if that's the public policy purpose, to warn future buyers, I don't see how that's a concern here.
The trust was the future buyer, Your Honor. And the trust has sold the property, but not that that is in the record, but that sale happened after this case was pending, so that wouldn't be implicated, but the trust is a future buyer.
Okay, I hear what you're saying. I'll look into the record. I understand what you're saying. Thank you, thank you.
I understand your argument that because the commission exceeded the specific scope of the remand, there's a big problem here. Could you articulate with great particularity what is the specific prejudice you suffered here, your client suffered by the remand, by going beyond the scope of the remand?
Well, there's one legal and there's one practical. Had they complied with the remand, it's our position that they would have been compelled to grant it, and half of this structure would not have already been removed, Your Honor. So that is a practical implication. That is not in the record directly. It is only referenced in the brief in connection with our concern that should there be a remand and that the commission is entitled to advance the argument that alternatives were not adequately presented or that there weren't available alternatives in reliance upon the emergency order, we can demonstrate, in fact, that it failed in 3 years and a portion of the structure has been removed. The other question escapes me, Your Honor. I can't remember.
It's the same question. You said that you had two bases to explain with particularity what prejudice you suffered by the commission going beyond the scope of the remand.
The legal prejudice is as the court pointed out earlier, by deviating from the directive that it be treated as a pre-August 10th, 1978 structure, there was no possibility of it being approved, and to the extent that that standard was there, and there could technically be an ability to demonstrate that somehow that coastal bank would continue to shed sand and provide sediment. I'm not an engineer. That no argument was made before the Conservation Commission on that point. Now, that may be a scintilla and the thinnest of arguments with regard to that point, but with regard to limiting the scope of the record, the Conservation Commission, from our perspective, took in information contrary to the instructions that were provided because at the time the applicant had submitted enough information to allow the Conservation Commission to make a decision. As a matter of public policy, there has to be some finality, right? It can't be that an agency or a department of the government has the ability to continue the process ad infinitum. Now, it's only a second time, but it was pursuant to an instruction from a Superior Court justice that this is what should happen. There's, from the applicant's perspective, what has occurred, or what should have occurred, would have been the normal, orderly adherence to the scope that was established by the Superior Court.
Understood. Let me see if there's further questions.
All right.
I know this is going to be a tough one, Justice Ditkoff.
Well, it's just
There's
lengthy.
two
The problem is
cases
going to be
here,
lengthy.
so
What's wrong with finding 7? There's finding 7 that says basically that even under the pre-78, the armoring the property will lead to significant erosion of abutting properties. And the beaches and that, you didn't really mention what was wrong with that finding.
So we did point out, actually, on page 50, I think, of our brief, that the error there is that the Conservation Commission relies on reports that were generated, I think one of them was in 2019, but all kinds of information that was introduced at the second hearing in contravention of the trial court's order. So we addressed that with regard to the initial Conservation Commission hearing by pointing out that there was no substantial evidence to support it. But we've addressed it on appeal by pointing out that to the extent it's the second decision, I should say it would be the second order that was issued by the Conservation Commission, it was tainted because they simply ignored the directives of the Superior Court and took in additional information that they should not have.
Okay. That was much quicker than I thought it'd be.
No. Thank you, counsel. And for the record, I commend you on your reply brief. We usually get reply briefs that regurgitate the entire argument. It was a very well-crafted 4.5 pages directed to an issue raised by your opponent, so thank you for that.
And I'm sure the lawyer that drafted it is watching this right now, Your Honor, so I appreciate it.
Attorney Braun.
Good morning, Your Honors, and may it please the Court. My name is Devin Braun, and I represent the Town of Wellfleet Conservation Commission in this matter. To start out, I'll address Justice Neyman's question about the first appeal. We would also agree that it's somewhat moot, though rolled into this proceeding in some way, and that it was the Commission's appeal initially challenging the determination of the 1978 status of the structure.
Whether it's moot or not, you agree that everything that's in the brief is properly preserved, correct?
Agree,
There's
Your Honor.
fine.
Thank you.
Thank you.
Now, the Superior Court appropriately entered final judgment on the pleadings for the Commission for 2 reasons in this matter. The first is that the second judge was entitled to reverse the prior interlocutory determination.
You say second because there's actually like 4 judges. You mean Callan?
That's a good point. Judge Callan was entitled to reverse the prior interlocutory determinations that the structure was entitled to the pre-1978 status. Because final judgment had not been entered, the Superior Court had explicitly retained jurisdiction over the matter, and that was at the insistence of the trust in the proceedings below.
Is it arbitrary and capricious for a case to be sent back on remand for analysis of issue B and then to affirm the Commission's determination based on issue A, which was not before it on remand? And if so, what authority do you have for that proposition?
Well, the Commission below disputed whether it was properly before it on remand, and in its second decision explicitly incorporated that first decision by reference.
But they don't get to set the terms of the remand.
It's true, and I think that the trust and the Commission both concede that the scope of the remand was not entirely clear. At first, the Judge Perino's...
That much is actually clear, yes.
So Judge Perino's decision at first had said you are to consider, whether the pre-1978 status, consider the use anew and consider the record evidence, and then a later decision said you have sufficient evidence in the record, and then that was, vacated, and it was somewhat unclear. But ultimately, I think the final 2 decisions, Perino and Gildea, both ordered that the public hearing commence within 60 days. What is a public hearing if not taking evidence and taking testimony? It otherwise would have been more appropriate to order that the Commission deliberate anew without public hearing testimony, and I believe the trust itself submitted evidence in the second remand hearing. But even if for some reason this court were to consider that arbitrary and capricious, the commission does submit that there is sufficient evidence in the record, the first record, even without its consideration.
What was the basis for Judge Perino determining that the finding or the determination that this was a post-1978 structure was arbitrary and capricious? What was his basis for that determination?
My understanding is that he determined that based on the omitted special condition set forth in the wetlands protection regulations, which says that no new structure can have a coastal engineering structure to protect it. And the fact that the commission erred in, not including that specific condition when it permitted the reconstructed property in 2010 somehow means that it was making an explicit finding or interpreting its own regulations to have concluded that this 2010 structure was not a new structure because it didn't include that specific finding. But as I pointed out in the papers, this case is being addressed under the bylaw, which does not require that special condition. So under the OOC issued under the Wetlands Protection Act, sure, that condition should have been considered, but under the Wetlands Protection Act, reconstructions are protected, so it's somewhat irrelevant. Under the bylaw, that special condition is not required. So he had
So your point is that even though that section of the CMR says shall contain the special condition of X, your position is it doesn't matter because the regulation under which is promulgated under the bylaw is more protective, more specific, and therefore it doesn't matter.
It doesn't contain that requirement of that specific condition. And I believe, I don't know, just to briefly address, I think it's undisputed by the trust that there is the authority to reconsider any prior interlocutory decision, and so I'll move on past the legal aspect, except as to just state that the trust has not cited to any legal authority, including in its reply brief, that stands for the proposition that the second judge was sort of required, that he wasn't allowed, we can't assume that that's what he was doing, reversing the 1978 determination, or that the judge is required to sort of explicitly state, I am undoing the actions of my colleague in his prior determination. The Lane case does not stand for that proposition. It's inapposite here because the two orders of the first judge and the second judge were in harmony, not in conflict, so they weren't reconciling an issue. And the two cases that were overturned for an abuse of discretion, the Barbosa case and the Howard case, were both reconsiderations where the first decision was not really at issue, and there was no prejudice to the defendant in that case, that the propriety of the first decision was not at issue. Here, I think it's pretty clear that, Judge Perino sort of clarified himself. It was clear that the first decision was not particularly clear or so as to that it couldn't be overturned.
And I apologize, I think I'm going backwards, but didn't Judge Perino himself say in one of his orders that even that on remand, the commission should address whether this was a pre-1978 structure? Have I got that wrong?
Did in his first decision.
And so to the extent that there's an argument from your brother here that he clearly established in some sort of estoppel kind of way that this was pre-78, the judge himself said, commission on remand, reconsider or consider whether this is pre-78. Do I have that right?
That's my understanding, and that's my reading of his decision in the amended decisions, and I think that that's why it's not arbitrary and capricious or some sort of erroneous determination to have characterized the scope of the remand order in this way, or for the commission to have said, look, it's somewhat unclear to us, we're going to reincorporate our prior conclusion that this is a post-1978 structure. It was constructed in 2010. It's post-1978. But nonetheless, we're going to respect the terms of the remand and go on to evaluate under sub 2 whether nonetheless the commission might, or the trust might be entitled to a coastal engineering structure for this property. And in turning to that sub 2 prong, which is really, it wasn't analyzed in Justice Callan's, but this is a de novo review. This court can obviously affirm on any ground that's apparent in the record, and the commission submits that in the alternative, it had substantial evidence in the record before it to support its determination that the trust did not meet the performance standards under the regulation for even a post-1978 structure.
Do you agree with your friend that finding 7 is based on, at least substantially based on new evidence, new as in beyond the first decision?
Finding 7 in the second
Finding 7 is the
decision?
one that says that this will cause unacceptable damage to adjoining abutters and beaches.
The second denial.
No, I don't agree with that because, and there's helpful evidence in the record at volume 2, pages 142 to 143, which is a document from the Massachusetts Office of Coastal Zone Management. That was in the first remand decision that explained while revetments can help protect buildings from waves and tides, they don't stop and actually can exacerbate erosion on beaches and dunes in adjacent areas, especially downdrift. That was one.
You just tell me what where that document is, but I was writing what you were saying, so I missed the.
Oh, it's a document on sort of why we don't favor coastal engineering structures.
You either said where it was or what it was called, and I just was writing other stuff.
Massachusetts Office of Coastal Zone Management.
Thank you.
Volume 2, pages 142 to 143. There was also...
So let me approach Justice Ditkoff's question a different way. Assume that we agree with Attorney Moriarty, we agree with the appellant that the Conservation Commission went beyond the scope of the remand and that was improper. What authority then do we have to consider their ultimate conclusion, right? What allows us to say, well, you went beyond beyond the scope of the order of the trial judge, of the Superior Court judge, but now we're going to come in and do what? Just, I don't know what authority we have to consider that.
Well, the scope of the remand still directed the commission to consider whether the trust met its burden of proving that it was entitled to a coastal engineering structure because there would be, 1, no adverse impacts, significant adverse impacts to public resources, and 2, that there were no feasible alternatives other than installing this very large armoring structure, the first of its kind, never been done before. And so the commission did just that, and there's ample evidence in the record before.
I understand what they did. I think the point is you can't put the toothpaste back in the tube. Once you've gone beyond the scope of the remand, we can never discern what portion of the determination came from evidence that the CONCOM properly considered vis-a-vis what evidence they weren't allowed to consider because it was beyond the scope of the remand. And I'm looking for some legal authority that guides us to deal with that kind of issue. It's not something we see very often.
Yes, Your Honor, and I'm not recalling a case that comes to mind per se, other than circling back to just
de novo review.
The evidence, de novo review, the evidence that was in the record before the commission, and the notion, the well-established notion that we do kind of assume that public officials are operating in good faith and not considering evidence outside of a record that they're not supposed to, but that would, require us to concede that the scope of the remand was clearly violated. And I think that a review of the commission's second decision and first decision sort of elucidates that it was unclear exactly what was being ordered, and to point out that that was at the trust's own doing. The motions to vacate, the motions to consider, the motions to amend judgment. That was all the trust's obfuscation here. The commission was trying its best to interpret and understand
I don't think I'd call it obfuscation. I mean, the trust saw a fairly unclear decision, and of course wanted it to be clarified in their favor, but I don't think was unreasonable, do you think, to ask for some clarification on that first order? You were just talking like it was a delay tactic or dilatory to ask for that.
No, I'm not saying it was a delay tactic or dilatory. I think that the confusion that arose from multiple attempts to sort of clarify, once they got the clarification, they still sought to then vacate the amended judgment. So it's just to point out that the commission really was doing its best in understanding and analyzed every prong of every sort of item that could be before it in order to give the reviewing court its best analysis to review. And I just wanted to touch briefly on sort of some of the evidence that it did have in the record to support that there would be a significant adverse impact. The U.S. Department of Interior letter, they submitted 3 separate letters. Whether the superintendent is an expert or not was challenged below, and the Department of Interior actually went out and got 2 other consultants who were experts, a coastal expert and a structural engineer, I believe, to agree and confirm that there would be an adverse impact to the natural disruption of sediment flow, the coastal armoring.
And those reports were submitted into evidence in the commission hearing before the end of the hearing?
Before the end of the hearing, but in the second remand hearing.
In the second remand hearing, yes. Okay. And those were not authored by the neighbor who the trust, whose credibility the trust challenged?
No, those were...
Right. Do you have record citations to those?
To the letters?
From their consultants.
From their consultants.
Or the 2 reports you just referenced.
I believe it's volume 5, 244 to 245. And I'd also like to point out the expertise of the independent peer reviewer who was in the first proceeding prior to remand, who also stated that if the revetment was approved at the proposed location, erosion and flanking would continue on the adjacent properties for abutters, for the natural resources, and that there were significant issues there.
Your time has expired, but I have a final question, and I'll preface this by saying I'm not an engineer. This may be a silly question, but the goal here is, my understanding is, you're trying to protect the, coastal resource area, et cetera. Would a chunk of a house or a house collapsing and metal and debris and sewage and electrical wiring and gosh knows what falling into that area and into the coastal resource area, would that damage that area?
Significantly, Your Honor.
So that begs this question for me, and it's not our position as an appellate court to say this, but I will just say this. If there was ever a case that begged for a non-litigious solution for both parties to work together to come up with some meaningful, expedited agreement to do something, this is the case that cries out for it. I leave that to you to deal with, but if both parties can give or what have you. In the meantime, we will decide this case. Very helpful briefing, excellent arguments, and the case is submitted.
Thank you, Your Honor.
That concludes our session.